So when you're considering this encounter, very similar to the encounter that Bridget was talking about yesterday, an encounter of two people on the street, think about that encounter of two people at a door, of a police officer knocking on the door and saying that they have some questions. And when you're painting that picture for the judge, we obviously want to paint a picture to the judge that that's an intimidating encounter that caused whatever action followed. So you need to consider tone of voice, the words spoken, the amount of knocks, when did they knock, the position of the officers, how many were there, how big were they? What did they have on, what were they wearing, what did the SOPs say, were they wearing their body cams? All of these things are things that go into that analysis of sort of painting the picture. And I ask you, when you're looking at these cases and thinking about how to argue them, to also consider the point of view. So very often we consider the point of view that we're arguing from the point of view of the police officer at the door. Consider it the other way. What does your client see, or your client's family member see, when they're looking through the peephole and it's the police outside? What is that interaction or encounter like for them? And try as best as you can to articulate that in your written motions and in your oral arguments. And I'll give you an example. So if we look at this encounter, you could say, and you know, back up for a second, and try to think about telling this in the language of story. I think as trial lawyers, sometimes we turn off the storytelling when we're not doing the trial. And motions are such a phenomenal place to do storytelling because it's not often done. So it's more interesting to judges. So you could say in motion papers, the officer knocked on the door 3 times and announced their presence, and after several minutes, the occupant opened the door and asked them if there was a problem. That's the mental picture that that's giving. Or in your brief, you could write, the officers knocked on the doors and the windows with their fists. They screamed police, not once, not twice, but at least 3 times. When no one answered, they knocked again until several minutes later, Claire Johnson opened the door just enough to pop her head through and asked the officers, is there a problem? That's the mental picture that you want the court to see. And by using language, like thinking about the language that we use when we're trying cases and using that in motion hearings, we can paint those pictures that Bridget was talking about yesterday morning. So plain view. So plain view, obviously we know what we need for plain view. And this is another area that I think we see a lot of police officers trying to get into our clients' homes. We all know that plain view alone doesn't do it. Just because an officer sees something, they have to be lawfully in the location from which they're making the plain view. So a lot of times we see this intersection in these cases of plain view and exigency, right? An officer looks through the window, he's on the sidewalk, he sees something going on in the house and automatically now thinks that he has a way to get inside. But what the case law tells us very clearly is that, number one, the police have to be in a lawful vantage point. Number two, it has to be a felony or serious criminal activity for them to be able to go inside, and the police can't create the exigency, so they can't purposefully put themselves in a position to see what's going on inside, like knocking on the door for the purpose of getting somebody to open up so that they can see inside. So when we're arguing these cases, we want to visit the scene, stand in the exact same spot the officer did, document the angle. If the door was, document how far open the door goes with charts, diagrams, measurements, photographs, and pay close attention to the way this house operates. How does the door open? Does it open in or out? How do the windows, are there blinds? Is there dirt? It's like my cousin Vinny, right? These trees with all these leaves on them. Are there obstructions? Is there something that would have prevented this police officer? Would he have had to move something in order to see the things he claims that he saw? And don't forget all the senses. A lot of these cases come from the scent of marijuana. Like officers walk by a place and it smells like marijuana, and now they're trying to figure out how to get inside. So not only looking at what the officer could have seen, look at what the officer could realistically have smelled. Anything that he could have insulated him from noise that he might have heard, and the distance where the officer was in relation to the interior of the home. Destruction of contraband is Another thing that we need to be wary of in these exigency cases, just because the item can be easily destroyed is not enough. There has to be some suggestion that the person was going to destroy it. So here we have to paint a picture of the nature of the emergency, the time that it would have taken to obtain a warrant, a reasonable belief that these people were in fact going to destroy the contraband, a knowledge of police presence, and the ease with which the contraband can be destroyed. So the ease is really only one part of the analysis that we have to consider. And again, the mere fact that it can be destroyed is not enough. I can't say how many times I've seen prosecutors stand up and say, well, it's cocaine. Of course, they could have flushed it down the toilet. That's not enough. You have to show something else. So you need to paint this picture that there's no way that this contraband could have been destroyed. Other forms of exigency, fleeing felon and community caretaking. I'd say Bridget and I had a great debate about which fuck the police picture was better, the girl looking over her shoulder or the girl in the tutu. I personally am a fan of tutus, so I like this one. So these are two other areas. I'm not going to go into them in great detail. Fleeing felon and community caretaking exceptions are just other things that you need to be aware of when you're looking at these cases. There are other ways that the state may or the government may argue that they can get into your house.
Like on this case, this is a Tennessee case, by the way. My client does HGN, walk and turn one legs, all the other things, and the cop wants to do the finger count. And she does it perfectly. And it's not in the report, right? So you see where I'm going with that. Is what you want to do is, let the prosecutor do that. Let them bring out all the bad facts. Let them do that. Let them lay this police report on thick. I'm going to start to say my favorite cop is the one that does that and has video. And so what the trial looks like is, there's a direct examination of the police officer, and good God almighty, why are we trying this case? The guy sounds like he's hammered, right? He's drunk as hell. And then before I even get to ask a question, I'm going to ask you to identify State's Exhibit 4. That's the DVD for my patrol cars. Have you reviewed it? Has it been changed? No objection, Your Honor. Enter it into evidence and watch it. And without me having to say a word, the prosecutor's momentum just shot up. That guy's wasted. Listen to what that cop has to say. He's reading from his report, and they see the videotape, and they're like, wait a minute. This guy's not nearly as drunk as this cop would have him out to be. And then you get in and you start picking apart the numbers and the field sobriety test, and whether the instructions were done completely, and whether they were done in the standardized manner, and whether they were 6 to 8 inches or 12 to 15, whether they turned the lights off. So it's almost with cops that want to lay it on thick in a police report, the momentum that you gain at trial from letting that play out and being the bringer of truth, as I said, to say, well, nowhere in this manual does it indicate that these tests are designed for impairment. If you've got jurors who are already preconditioned or receptive that this sounds exaggerated to me, and you can hone in on that and you can sort of give jurors what they need to validate that feeling that they have that this is kind of being sold to us, I think you're halfway home to a not guilty there. Does that make sense? So the short answer is, that's a very long answer. The short answer is I've never filed that motion. I think it's probably a legitimate motion, but it's one of those throw me into the briar patch type things. I've had cases where a cop has really butchered the HGN. And that's a really tough call for me as a lawyer because I'm convinced that jurors give an inordinate amount of credit to horizontal gaze nystagmus. I don't know why, but my experience is jurors buy into that crap a lot more than just about anything else. And so it's a tough decision because there's so much opportunity where a cop has screwed up an HGN to shift the focus away from I saw 6 clues to you didn't do these tests right. How can you expect my client? If our expectation is of this citizen who is accused is they're going to do everything right in the field sobriety test, is it not fair that we ask the same from our police officers?
So that tells you how powerful the dog's nose are. So can the dog do this job? Yes. Can the dog find narcotics in a vehicle? Yes. Can they find it in a car? Can they find it when it's buried? Absolutely. The problem with the narcotics dog is the training, the selection process, and the handlers. All right, what do you need for me to determine the effectiveness of a thief? So what you need to get in your discovery is hopefully the video of the search. We don't always get that. In the case of our Kansas case, we have a video. In the case of our Las Vegas case that I'm coming back for in a couple weeks, we have a video. But sometimes you don't. So minus the video, then these other things are really, really important. In the case of a video, there's been some cases where all I've needed was the video, and I could go in there and say, this is BS. Yeah, this is BS. And, you know, this isn't really a good search. But minus the video, you need the canine detail policy, the procedure manual. That will provide me with the selection process, you know, who does the selection, who their trainer is, and all that kind of stuff. That all should be in there. If it's not included in the canine policy, then we need to have that added as an addendum. We need the training records, all of them that they have. We should have training records. I did a case in New Mexico. It was a federal case. It was a DEA case. And they had no training records. They had no deployment records. They had no certification records. They had no video of the dog and no pictures of the dog. And they didn't know where the dog was at the time of our trial. So when I got the case, we didn't even know if the dog even existed. All we had was something from the officer's breast pocket from one of those little, you know, pocket little note-taking things. That was his report that said the address where he went and the amount of narcotics that was found. That was it. Didn't even have the time of day. Didn't have any more details. That's all we had. So we were able to get that case thrown out because there was nothing, absolutely nothing. I don't even know if the dog actually even lived. Deployment records. Deployment records obviously are those records that the reports that they write when they actually use the dog out in the street. So they should have deployment records. They should keep track of those. Certifications. Certifications should come from a reliable source, a reliable certification. In the case of the New Mexico case, they did find one piece of paper that said this dog was certified by the same officer that handled the dog. His name was the signature certifying officer. That was the one thing. I forgot to tell you that part. But he had a certificate that was signed by the officer. He was the handler and the certifier. That doesn't count. All right. A sergeant should be the sergeant for the canine detail for the same department should not be the certifier. It should be an outside agency or somebody that's unbiased, of course, in that type of situation. The handler bio, CV or hero sheet, as we call it, we should have that, and the veterinarian records. Those are last on the list. I'll tell you where the veterinarian records did come into play, and that's on a dog that we found out was stabbed in the muzzle during a confrontation with a suspect. And that dog had to have surgery on his olfactory system. If you don't think that that may affect the dog's chances of finding narcotics, then something's wrong. I had a tough time with that one with the judge, but he did not want to. He so badly wanted the narcotics in. But I have to battle of course, the federal judge is a little bit more difficult sometimes than the other judges. But I was able later to convince them that was a serious issue. I think there was even an infection early on in the healing process. So that was really important. Plus,
what is happening in our country, what has happened in the history of our country, it is not a joke. It is factual. It has happened. It impacts real people with beating hearts, with brains, with blood, and everything that's inside your skin. And if you don't think that it merits a sentence or a paragraph or a freaking mention when you step in court with them, it would explain why the criminal justice system has gotten to the point that it is. I need you to think outside the box. What I'm seeing a lot of times is that folks like to file the same motion. They got a standard motion to suppress they give to the court. I got the motion to suppress for the car case. I got the motion to suppress for this. Look, Fourth Amendment challenges are fact-specific. And you can't make a fact-specific analysis if you're pulling a motion from someone else's case. And I'm not telling you that you can't go through some of the law and pay attention to the way the law happens, but you've got to think outside the box. If you filed them, here's the thing. What do they say the definition of insanity is? Somebody. Exactly. So if you filed that motion 10 times and you haven't won, why the fuck did you apply? Why did you file it an 11th time? It didn't work for you. It don't work for you. And here's the thing. It's not the judge at that point. That's you. That's you. If you're filing a motion that just isn't winning over and over and over, I switch it up. Now, I want to make sure I'm clear. I'm not saying conceptually you don't make the same challenges. I'm saying you don't file the same motion. If it didn't work in front of that judge this way, then you need to change the way you wrote it. Maybe you need to add something different. Maybe you should add some statistics because that works sometimes, right? So if the cops stop you, do you have to talk to them? Anyone? No, you don't have to talk to them. But if they pose a question to you, is that a violation? Correct. Yeah, so that's just like basic, 101. Everyone passed the bar exam. Yay, we're all smart. Let's get it going, right? So, we have that there. To determine whether or not an encounter is consensual or not, it depends on whether or not, there's show of force, whether the client's in a particularly vulnerable state, whether they've been subjected to police pressure, they're a member of a minority group with a strained relationship with police officers. Yes, I put that there. I know most people don't put it in their motions, but it should be there. Does the client have a history of traumatic interactions with the police? Yes, I know it's not a subjective test, but if you want to make an analysis to any of the civil cases, it can be subjective. You will lose at this point, but it doesn't mean that we can't win in the future. And a pattern of police engaging in a discriminatory practice, which is a little bit harder to prove and something that you have to contemplate when you first get the case because it takes a lot of time to gather that information. So all of those things determine whether or not an encounter is consensual. But this is what I would like to ask you. If right now you're walking down the street, let's just hypothetically say you've done nothing, and a cop comes up to you and they say, what's your name, sir? Thomas Johnson. They walk up to you, Mr. Johnson, and they say, sir, come, I want to talk to you. Would you feel comfortable walking away? You feel comfortable walking away? You would walk away. Kudos to you. Kudos to you. I've told my son to never turn his back to a cop when he wants to talk to him. Okay. Is there anyone else who would be comfortable walking away from a cop when they want to talk to you? There's no one else? Come on, raise your hands. There are other people in here that are comfortable walking away. And there's nothing wrong with being comfortable walking away because it's your constitutional right to walk away, right? But here's the thing, man, it was constitutionally correct for Sandra Bland to say, no, I'm not getting out my damn car. She's dead. It was constitutionally correct for, Eric Garner to simply ask, why are you always harassing me? He's dead. It was constitutionally correct for a whole lot of people who are 6 feet under right now to say, I don't want to have this conversation with you. So I think that instead of making the analysis on consensual encounters what it's been all these years, I have it on good authority talking to a lot of people that they just don't feel comfortable walking away. Nobody would feel, a good majority of people wouldn't feel comfortable. And this is what I will tell you. In this room of lawyers, there was not a 100% consensus that people would feel comfortable walking away from law enforcement. So this is what I want to ask you. If you don't feel comfortable walking away from an officer with your law degree, your finances, and your public stature, why would someone who is not like you feel comfortable walking away?